morning. It's the media's turn.
It's for later.
Okay.
Sorry.
Okay, we're here for the media's motion. Supplemental motion concerning access to evidence admitted at trial. And Mr. Cruz doesn't need to be present for this, correct?
No, it is not. It's not a critical stage of the proceedings.
I agree.
His appearance.
Okay, and the state's present? Ms.
Yes, Your
McElroy,
Honor.
you want to come on up and let me know what it is that you're asking for? Please?
Thank you, Your Honor. May I move the podium a little bit?
Sure.
Good morning, Your Honor. Dana McElroy, here representing the Associated Press, Gannett Company, Inc., the Miami Herald, the New York Times, the Sun Sentinel, Tegna, and Times Publishing Company. In our motion, we seek access to evidence which is admitted into the court record and would be shown to the jury. We have broken down our request to two separate categories which are important for the motion. One is evidence which is admitted, which is not sensitive or graphic. And I'll call that, for lack of a better term, the regular evidence. And then secondly, there's sensitive or graphic evidence, which would be crime scene photos, videos, autopsy photos, things like that. And in that situation, we're seeking, as to the sensitive evidence, only to view and not copy or in any way duplicate what is admitted into evidence and considered by the jury. So just as I go through, I'll refer to the regular evidence in one way and the sensitive evidence in another. As a preliminary matter and as recognized in numerous U.S. Supreme Court cases and Florida cases, jury trials are presumptively open under the First Amendment. The reasons for this are undisputed. The reasons for this is an undisputed constitutional right under the First Amendment. And it's articulated on page 3 of our motion in the Richmond newspapers case, where the court, U.S. Supreme Court, explained, public scrutiny of a criminal trial enhances the quality and safeguards the integrity of the fact-finding process, with benefits to both the defendant and to the society as a whole. Moreover, public access to the criminal trial fosters an appearance of fairness, thereby heightening public respect for the judicial process. And in the broadest terms, public access to criminal trials permits the public to participate in and serve as a check upon the judicial process, an essential component in our structure of self-government. In sum, the institutional value of the open criminal trials recognized in both logic and experience. And I'll just pause and also advise the court that I have, in the run-up to this today, and I appreciate the court's time, conferred with both the state and the defense in this matter, and neither opposes our motion.
I don't understand what you're asking for.
Okay.
And I don't understand the difference between the two, and I also don't understand why it is that what I've given you, the access that I've given you, is not enough.
Okay, if I may, I'll continue just a little, and then I can answer your question.
Okay, I've read your motion. I really don't need you to expand on the case law. I understand it. You can go ahead. You can read the case law to me.
That's okay. I'll do whatever the court would like. I would just like to make sure I make a record, but I can try to answer the question. If I don't, maybe I'll ask one of the parties to assist me.
Okay.
Because what I understand is that there will be a subset of evidence that is proffered by the state. We'll start with the state. That is what we would consider regular, non-sensitive evidence. In other words, evidence that will be accessible to the public immediately or contemporaneously, maybe on these monitors, or maybe otherwise. And I believe we're making a distinction between that kind of evidence and the sensitive or graphic type evidence, which we're not asking for access to contemporaneously at all. What we're asking there, and those are crime scene photos, autopsy photos, other things that are invoke or...
Exactly. Okay, let me stop you because I'm not understanding. With regard to regular evidence, how are you suggesting that the media be able to view it? Tell me the exact process you're proposing.
Either how you said yesterday, where we come look at it, or it'll be displayed on the monitors. That's not a difficult question.
Okay. And then how are you proposing to view the sensitive evidence?
What we are proposing is that we be allowed to, as I understand the process, it's going to be shown to the jury if admitted, and I'm only talking about admitted evidence.
I understand.
Okay. It will be shown to the jury on these monitors, but will not be shown to the public in any way or broadcast. In other words, it'll be cut.
How do you propose that the media views it?
Okay, that we'd be able to come and look at it at some point that doesn't take up the court's time and resources in a secure manner.
Okay, I don't understand I still don't, that's exactly what I did yesterday. So what is it that you are complaining about?
Well, what I understood from yesterday is, first of all, if you're just saying we can come up and look at the clerk, we're talking about possibly hundreds of photos. We're talking about videos. We're talking about, so it's a big world of evidence that is not easily that we can just walk up to the clerk. That's not in a secure way. In other words,
my plan is to have everyone leave the courtroom except for the media representatives. Then I'm going to be here, the sheriff's office is going to be here, and the clerk's going to be here in open court, which is the most secure way that I can give you.
okay.
And then my procedure was that the media can have several representatives, depending on, you all can decide among yourselves who's going to be the representatives for that day. And then I'm going to give you what I said was a reasonable amount of time to view the evidence. Now, if we finish at 7 o'clock at night, the clerk and I are not, in the sheriff's office, we're not going to stay here till 9 o'clock at night to watch you view it, and I don't think the law requires me to do so. I'm going to give you a reasonable amount of time at the end of each day to view the evidence.
So that would include the sensitive evidence?
Yes, everything.
Okay, I just want to make sure that that is acceptable to the state and to the defense, because the state had concerns that and Your Honor can, of course, order this, and we would have to comply. We would be willing to comply, obviously, but that there not be the ability of maybe an outlier to take a picture or somehow duplicate.
That's the reason, state. That's the reason that I want to do it in the courtroom with myself sitting here.
Okay.
I don't want any lawyers, no one except for myself, the sheriff's office, and the clerk. We will be here. That way I'm here observing what's going on. The clerk's here observing what's going on. We give them a reasonable amount of time. At the conclusion of each day, it will be secure. The sheriff's office already knows they're going to be part of this. And if the media anybody tries to do anything like take an illegal picture in front of the judge and the sheriff's office, then shame on them.
Your Honor, and the state appreciates the concern that the court is obviously, the thought and concern the court has put into this. And I would suggest that in the old days, when there used to be a bench and a gate before the parties could approach,
Sure.
that maybe the media leave their bags and their cell phones and their personal effects behind before they approach to look at the photographs, because as Ms. McElroy and the state discussed, I'm sure she discussed it with the defense as well, and I know we brought it up to the court, that we don't want anyone to surreptitiously take photographs of this evidence with their watch, with glasses, with a cell phone in a pocket, with any sort of device. And so we would ask that, I know you're going to be watching them, but I just want to make sure that since no representatives from the state are going to be in here, and assumably none from the defense, that those safeguards are put in place.
Look, if you all want to have a representative from the state and the defense present, that's fine with me, but I thought it would be easier for you all to not have to stay every night of the trial and do that.
We have investigators who can do that, Your Honor.
If both sides want to have an investigator here, that's also fine. I'm also going to have whoever is the, I don't know if you all are going to elect them, appoint them, the media representatives for the day. We're going to have a sign-in sheet, and they're going to write their name and their agency, and we're going to make sure they have a press pass, which they shouldn't be in here if they don't. That way, if anything like that goes on, there's a recourse.
That's fine, and the procedure that Ms. McElroy has laid out is agreeable to the state, and it is exactly what this court has laid out as well, Your Honor. I think there was just a misunderstanding as to maybe more was granted than was necessary, because with regard to the regular evidence,
Right.
it's going to be readily available for everyone to view via the monitors that are going to be available in the courtroom, and we're really only discussing sensitive evidence for the procedure that you envision.
Okay?
Thank you, Your Honor. That takes care of our motion and our concerns, and I appreciate that.
Okay. So if the state and the defense want someone to be here for this process, I'm just going to ask that you let me know who the person is, and we're going to have both sides here every day. You see what I'm saying? If the defense side isn't available one day or the state side's not available one day, I don't want one or the other. I want both or neither.
Okay.
Please.
We'll probably know that as the day goes on. I don't know that we'll know that in advance.
That's fine.
But we'll get with the defense and work that out, Your Honor.
Okay.
Your Honor, are you going to have like a table in front for the evidence?
We can, why don't you have, why don't you all speak to Hortense about exactly what you want?
Okay.
She's been through this process.
And we've worked with Hortense before,
Right.
so she knows what we...
I'm sure she knows what you need. She's been in a big trial. That's why they graciously assigned her to me for this trial. And let her know what you need, and then we'll get it done.
Okay, perfect. Thanks, Hortense.
Thank you.
And the same for you, Ms. McNeil.
Thank you.
Sure. Okay, is there anything else?
Now, Your Honor, would you like me to submit an order, or?
We'll do a written order.
Okay.
I'll do a written order, okay?
Thank you.
All right, thank you. So, was it 1 or 1:30? I can't remember.
1:30.
1:30. All right, we'll see you at 1:30. Thank you.
Judge, just so you know, that's the redaction. It's amended. You were correct
So
yesterday
should I
night.
throw away the one from yesterday?
Yes.
Thank you.
Thank you for letting
Should
me
I
know.
throw away the transcript from yesterday?
Yes, I gave you a color copy.
Okay.
And
It's
state.
thinner because it's double-sided.
Yes.
Okay.
The state has the same. And then you wanted the video, and that's what that was.
Thank you.
I assume
Yes.
if I have a laptop set up, I'll assume you'll have to have a laptop set up. A personal laptop, not their own laptop, because then they can move files on there.
So at the end of the day, I
So
take
like
it
record
into the.
record part of it or something.
What do you need?
Or the judge can turn her screen around. Control it.
That's what I need to know, because I don't want this to happen last minute where they.
Right. Yeah, I'll find it. Yes. There was nothing it was all already settled.
Yeah.
Or maybe even easier. So